Call the meeting to order. My name is Frank Rory. I'm the Vice Chair for the Rent Stabilization Commission. Today is Thursday, January 23rd, 2025. We would like to begin this meeting by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Quiche peoples. At this time, I would like to invite our 10-and-a-half-year resident, the City of West Hollywood, Vivian Molina Rory, to the podium to please lead us in the saying of the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great job. Thank you. Mr. Secretary, could we have a roll call, please?
Commissioner Goldman.
Present.
Commissioner Kerpes.
Here.
Commissioner McCafferty.
Here.
Commissioner Paris.
Here. Commissioner
Commissioner Topshin.
Here.
Vice Chair Rory.
Here.
And Chair Bass is absent this evening.
Great. So we have a quorum. Our next item is the approval of the agenda. What I was going to suggest tonight is that we have three matters. One of the matters has both sides here present, and the other two have a hybrid Zoom situation. One's fully Zoom. So in the interest of the folks who are here, I was going to suggest that we do that matter first, and then we'll get to the other two. So if everyone's had a chance to review the agenda, my proposal would be that we amend the agenda to do the D4804CD matter first, and that's the matter on North Sierra Bonita Avenue, and then we would next do the order that's on the agenda. We can do the Norton and then the Edinburgh property.
With that modification, I move to approve the agenda.
Okay, we have a motion and a second. Do I hear a second?
Oh, yes, second.
Okay, and all in favor, please say aye.
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 Any opposed? None? Okay, so that will be the agenda for tonight. The next item is the approval of the meeting minutes from our last meeting in November, 14th of 2024. If everyone's had a chance to review, I can entertain a motion to approve.
Motion to approve?
Motion made by Commissioner Kerpes, second.
Second.
Second made. All in favor, please say aye.
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 Any opposed? No one opposed. That the meeting minutes are approved. And now we move on to public comment. There will be an opportunity to speak individually on individual matters, but at this time, are there any public comment?
No speakers at this time.
Okay. So moving along, we have our manager report. Mr. Kessinger, could you give us a report, please?
Of course. Good evening, Commissioners. Happy New Year. I know that 2025 didn't start off in the way that many of us had expected or hoped, but I'm very glad to see you all here and well. I'm going to start before going to the look-ahead calendar with two announcements. My first announcement is a reminder on behalf of my colleagues in Neighborhood and Business Safety about the West Hollywood Ordinance prohibiting smoking in multifamily dwellings. So a reminder to everybody that effective July 15th, 2021, smoking tobacco, cannabis, and vaping are prohibited in common areas of multifamily dwellings. Smoking tobacco inside all new multifamily dwelling units is prohibited, and smoking tobacco on private balconies and patios of new multifamily dwelling units, including new tenancies, is prohibited. That was subsequently expanded effective January 1st, 2023, and smoking tobacco inside all existing multifamily dwelling units is prohibited, and smoking tobacco on private balconies and patios of existing multifamily dwelling units is prohibited. For more information on the prohibition on smoking in multifamily dwellings, you should feel free to reach out to 323-848-6516. by emailing code@weho.org or visiting weho.org/smokinginfo. I also wanted to announce that on January 21st, 2025, the City Council unanimously passed an urgency ordinance which, among other things, provides an emergency exemption to the city's minimum one-year lease term requirement in certain situations where landlords rent a unit to an evacuee of the 2025 Southern California fires. The city is currently preparing a form which landlords who wish to enter a lease agreement for a period of more than 30 days and less than 1 year with an evacuee of the 2025 Southern California fires should complete and send to rsd@weho.org within 30 days of the start of the tenancy. More information on the form, including where to access it, will be available shortly following the form's release. Landlords and tenants should be aware that existing tenant protections in West Hollywood, including prohibitions on evictions without just cause and tenant harassment, are not waived for evacuees of the 2025 Southern California fires on the basis of a shortened lease term. If you have questions on the evacuee waiver form, tenant protections in the city, or any other rent stabilization matter, please feel free to contact the Rent Stabilization Division at rsd@weho.org or by calling 323-848-6450. Moving on to the look ahead calendar, we have 3 appeals scheduled for tonight. For the meeting on the evening of February 13th, we have 2 appeals and some guest speakers from other divisions in the city, including the Human Services Division, who will be providing a presentation on service priorities for 2025 through 28 funding process, and our long-range planning division, who will be making an announcement on equitable building performance standards. On February 27th, we'll return to having 3 appeals, and we'll have 3 appeals on the evening of March 13th, March 27th, and April 10th. At this time, there's only 1 appeal scheduled for April 24th, but if we continue to be a little bit behind on the 150-day timeline, we will continue the scheduling of 3 appeals per night in the absence of staff announcements or presentations. That concludes the manager's report at this time, but I'm available for any questions the commission might have.
Good evening, Mr. Manager. Just a quick one. You mentioned regarding the prohibition of tobacco use in the residential units. Is this this applies to tobacco only, or marijuana use as well?
So it's a little bit different. The most recent, and I won't get too into it, I think it's probably appropriate for the subject matter experts and neighborhood and building safety to sort of reply to in-depth questions. But there are differences, and I would encourage folks to reach out. The most recent developments were just applying to tobacco for all units in the patio and in the unit itself.
And you mentioned something about new tenancies. Is this the rule for the new tenancies or for tenancies prior to July 1st, 2025?
So certain of the prohibitions are for new tenancies, and depending on sort of what the prohibition applies to, whether it's tobacco, cannabis, or vaping, as you noted, some, like for example, the tobacco applies to all units.
Okay, all right. And you said where we can find this information, a little bit more over there?
At weho.org/smokinginfo, or by reaching out to Neighborhood and Business Safety at code@weho.org, or by calling 323-848-6516.
Which is the department's number, right?
Correct.
Okay, thank you, sir.
Commissioner Kirby's.
Yes, thank you. Just have a question to follow up on the announcement about the short-term leases. That, when you talked about the waiver, that means that even though somebody offers a short-term lease or 30, 90, maybe 6 months, that doesn't necessarily mean that the individual has to move at that time, correct? The waivers that you talked about were for, they still have to there be a reason for them to be evicted.
Correct. There's no evictions allowed without just cause, and the fact that a lease ends in and of itself is not just cause for eviction.
Great, thank you. And then one other question you didn't mention, but can you talk a little bit about what our harassment policy is here, or I guess what I'm trying to get at is the rent gouging and the opportunities that people might feel that they have if they were to convince a tenant to leave. Could you just talk about that a little bit? Just who, if you feel that you're being harassed, who to call, things like that? Thanks.
Absolutely. So if there are any examples of harassment, please, any tenant that feels there is a situation where they're being harassed should reach out to rsd@weho.org or call us at 323-848-6450. There is a complaint form that can be submitted, and we're happy to walk any tenant through that complaint form who has questions about what that process looks like.
Good questions. Anyone else? Okay. So at this time, we will move on to the appeal portion of the evening. And as mentioned earlier, we have 3 appeals. The first one we're going to do is the North Sierra Bonita Avenue appeal, and that is D4804CD. And so at this point, if Commission Council could give us a report, that'd be great.
Absolutely. Thank you, Vice Chair. My name is Kellen, legal counsel to the Rent Stabilization Commission. If you'll indulge me to make 2 quick announcements before I go into the appeal. I just want to extend my condolences to everyone affected by the fires that we've been going through. Something that I represent more cities than just West Hollywood. Typically, we're pretty on time here, but with 3 appeals, what tends to happen in my more chatty cities is that we spend a lot of time on the first appeal and we get to the 3rd appeal and we are very tired. I just want to try to keep everyone mindful of that on your first appeal so that we don't shortchange and make potential errors on that 3rd appeal. And then just briefly on the price gouging, we did see the Attorney General file the first criminal case against a potential price gouging real estate agent in La Cañada today. So those issues are being looked at by the City Attorney of West Hollywood as well as the local district attorney and the Attorney General's office. So if you do see those, please do report those to the City Attorney's office, to RSD. They can forward them to us or to the Attorney General's hotline on those. And we will turn to our appeal now. So on the first appeal, we have D-4804CD. For the audience, CD refers to compliance determination. This is an appeal related to 916 North Sierra Bonita Avenue, unit number 18. This is a compliance determination issued by the hearing examiner in July of 2024. That compliance determination decision granted a partial restoration of rent based on the landlord's compliance with repairs ordered in an original hearing decision from October of 2023. The tenant appeals, citing several aspects of the determination. He claims that the decision is clearly an error, not supported by the findings or evidence in the record, and an abuse of discretion. There are 5 main components of the appeal. First, that a $5 restoration was mistakenly counted twice, disputing the $10 restoration for the cracked and peeling paint in the second bathroom tub, $25 restoration for door handle locks, $14 for window screens, and $30 for balcony roofs, supports, and railings. The tenant is also disputing the finding in the compliance determination that the tenant's actions contributed to the landlord's inability or difficulties to complete certain reviews. Staff recommends affirming the compliance determination in full with the exception of fixing the $5 mathematical or double counting error that was noted by the tenant in the appeal. The tenant in this case has lived in the property since 2004. The original application was for a number of housing service issues related to the unit, including damaged walls, mold, paint, and fixtures. There was an original decision that reduced the rent by $463. That is itemized in your staff report. I won't repeat them due to the length of them, but there were 18 issues. Subsequent to that, the landlord filed a compliance determination request to have the rent restored for certain items, not for all. A hearing was held on that compliance determination request with a decision being issued on July 31st, 2024. In that decision, which is the basis for the appeal tonight, $151 was restored of the original amount of $463. There were 13 items that were restored. Again, those are located in the staff report. I won't go through those again. And tonight, the questions to be determined by the commission are 5-fold. Was the $5 restoration mistakenly counted twice? was a $10 restoration for the bathtub supported by substantial evidence. Same questions for the $25 rent reduction for the door handle locks, the window screens, and the balcony roof supports and railings. You will see it on page 603 of your packet, which is the second to last page of the compliance determination. Staff has found that the tenant is correct that the hallway closet door restoration was counted twice. You'll see a $5, then another entry, and then a $5. And that's on the right-hand side where it's a little calculation table done by the hearing examiner. The cracked and peeling paint in the bathtub, there was evidence presented by the landlord with testimony and photographs that the painting issue was resolved. Tenant has stated that it was not done correctly. However, the regulations require substantial compliance, not perfect compliance. As to the door hearing locks, this was found to be by the hearing examiner that it was due to tenant's failure to coordinate with the landlords and to making it difficult for the landlord to schedule those things. Window screens, same issue with the tenant's difficulties in scheduling with the landlord. Excuse me, and same to the balcony roof supports and railings. So in conclusion, staff recommends that the Commission uphold the hearing examiner's compliance determination decision with the exception of fixing the $5 counting error. That concludes my report, and I'm available for questions.
Do we have any initial questions for council? Not seeing any at this time. I think we can move on for oral argument, and then we do public counsel after. We do public comment again after oral argument. Okay. So since at this point I'm going to call forward the tenant, who is the appellant on this issue, Mr. Alex Potashev. And so you're going to have 5 minutes to address. You're going to have an opportunity for a rebuttal. So whatever time you don't use in your first 5, you will have for your rebuttal. Okay. Is that clear? Mm-hmm. Okay. So, sir, you may begin.
Okay. I just wanted to make a correction for the issues, except for the closet door. The problem was that they were not fixed, and the inspector, or basically they were not done, and they were just put in as a punishment for them not being completed in time. But I just want to make clear that at no point did I ever prevent the workers from entering my apartment or doing the work. In the time span of 11 weeks that they were working, they themselves were not available for more than 4 weeks. Usually it would be a thing where they would not show up on one of the days. Like, they were supposed to show up from Monday through Friday, but some days, let's say on Tuesday, they would not show up, and they would not contact me. I would not be told that they would not show up. I would call them, and they would say, oh, we had an emergency. Over time, I started to understand that they would have an emergency every time that they would take their tools from my apartment. So if they would show up next day, they would not take their tools. They would leave their tools in the apartment. But on days when they would not show up next day, they would take all of their tools, and then next day, I know for sure that they will tell me that there was an emergency. They had multiple other jobs that they would make, and therefore they were not available to perform the work that they said that they would. In regards to any of the most of the issues, screens, they could basically replace all of the screens at the same time, but they only replaced 2 screens and then just didn't do the other 3. For the balcony supports, no work has been performed at all. For the bathtub, the issue was that there was a crack between the tub and tile, and water would collect there and create mold. That issue was not resolved, even though they attempted to resolve it on multiple times. but they did not fix that issue. So, when the inspector from the city hall came, she documented that the crack was still present and water still collected in that crack.
Okay, thank you, sir. Are there any questions at this time from the commissioners? Commissioner Topchin?
Good evening, sir. When was the inspection happen in the unit?
I believe it was September
September of 2024.
Yeah.
Okay.
Commissioner Kerpes?
So I just have a question about the work being done. It doesn't sound. I don't think the allegations were that you refused to allow them into your apartment to do the work. I think it was a situation where they would come do some work, come back to finish it, and changes had been made to the work that they had done. And I know that that was specific to the closet, and well, it doesn't look like the heater is an issue here, but were there other times that, did they start work on the balcony? Did you disagree with the work they were doing?
On the balcony. As far as closet, basically, they started work on the closet probably a month before they left. And at that point, it was right around Thanksgiving. So basically, by the time Thanksgiving came, the closet doors, they would not touch either end of the side, that there was sliding closet
No,
doors.
I understand. I guess my question is, so on the other issues of the window screens, the door locks, and the balcony issues, at any time did they start work and you asked them to change their work or do something different?
No.
Okay. Thank you.
Go ahead, Commissioner Paris.
So I hear that, and I want to better understand regarding the closet doors. And the materials that I have seen, there are communications from what I believe is the vendor who was supposed to do the repairs about their inability to complete the work. And I hear your testimony here that they would cancel or they would not show up at the appointed times. Is there anything in any documentation of that? I haven't come across it in the packet.
No, so during the original hearing, I did not feel, I felt that I should just stick to the facts, and the fact was that the work was not completed. I was mistaken in thinking that it wasn't relevant why the work wasn't performed, but then in the compliance determination, the determination was made that because I was preventing the contractors from doing the work, that is why these things were listed as additional deductions.
Okay, thank you.
I have a quick question, and I just want to be clear. In the record, there's a letter from the vendor or the contractor saying they were quitting the job. You don't dispute that the contractor ended up quitting the job, do you?
I do not, no.
Okay. And if I heard you correctly just a moment ago, these were the testimony you gave tonight about your view on what happened. You chose not to bring that up at the compliance determination hearing because you wanted to focus on other issues. Is that correct?
Yes.
Okay. Okay. Are there any other questions at this time? Okay, great. So thank you, sir. We're going to have you just take a seat real close, and then you'll have a chance to come back up. And I'm going to invite the landlord at this point to come forward, or the representative, Mr. Leo Hirschman from MZL Properties.
Good evening, I'm Leo Hirschman. I work with MZL Properties. I'm the supervisor for the property.
Very good.
I brought their contractor and his son with, and they were ones who were working at the apartment.
Could you move the mic just a little closer?
Okay, okay. Better?
Yes, sir.
So I think in August of 23, they went there to do an estimate for us for upgrading and repairs. They gave us an estimate. We gave them a half deposit. And I believe in September 23, they started to work in the apartment. After a few weeks, he called me and told me that everything they were doing, this guy was interfering, taking down, because the tenants were living there while they were doing all this. And he complained and complained. 2 months, in January, he sent me a letter saying he cannot work anymore there. Every time they do something, it gets removed. I don't know if this guy was doing a decorating job or what was going on, but they interacted more than I did. They were there all the time, so they can give you some more information of what transpired. He still works for us. We have no issues when he does the job. What transpired there was a nightmare. I wasn't there, so but they can vouch for what transpired, because the tenants were living in their premises at that time, and he wasn't working, so it was pretty tough trying to work there and do all, replacing floors and doing this, doing that.
Okay. Thank you, sir. We'll open it up to any questions at this time. Commissioner Kerpes?
Thank you. I have a similar question along those same lines. And I'm asking this question not because I am convinced that it would be relevant in the end as we make our decision, but I do want to make sure I'm not missing anything in the record. It's my understanding that the record shows that the disputes were specifically about the work being done in the closet. I think there was the heater issue, that there was work being done and then they'd come back and the work would be either taken apart or changed somehow. I didn't see anything, and correct me if I'm wrong, but I didn't see anything about specifically about the balcony and the screens and what's the fourth thing? The door handles. So did I miss that, or was the belief that we can't work with this individual any longer? We've tried, we're working on these projects, and we just can't do it anymore, and that was the reason for the letter.
That's why I brought them tonight, so they can give you their views and tell you what transpired there.
Yeah.
I didn't integrate with them as much.
I guess I want to make sure that I didn't miss anything in the record like that was already testified to.
Okay.
And so my other question is, and again, I don't know if this will have relevancy later on, but I want to ask it so that if it does, it may play a part in my decision. But when they said they could no longer finish this job for you, did you make any attempt to get a second contractor at all?
No, I didn't, because contractors don't like working on other people's work. I thought we could resolve this and get them back there without him interfering with them all the time. That was my idea.
Okay.
But it just didn't
Again,
work.
I don't know if that will be relevant in the end, but I just wanted to know. Thank you.
Can they come up and talk?
Actually, sir, you're the landlord representative, so you can confer with them and speak. But you're the representative, so we have to limit it.
Okay, because they were interacting with him every day. He wasn't working. He was on top of them, telling him to do this, take this down. Closet doors come. The next day, the closet doors were gone, down. So, I mean, it was...
If you want to ask them right now if they have anything to add, you can, because after this, you won't have another opportunity to
That's
speak.
fine.
Okay.
We went in good faith to do what we have to do. And it didn't transpire with this guy. It just didn't work out. Okay. They still work for us. They do jobs. We don't have no problems.
Okay.
Upgrades, remodels.
Any other questions? Okay. Thank you, sir.
Thank you.
You can have a seat. And then I'll invite the tenant to come back with the remaining time. Mr. Secretary, could you remind him roughly what he has?
2 minutes and 24 seconds.
Yes. So I was just, when I was saying that it was done as a, in the decision from, it says, tenant's rebuttal testimony did not establish that the failure to perform the work was not caused by any of his intentional actions. Due to this determination, the rent will be restored for the following items, and then it lists the items that were restored and that I'm appealing. Primarily because I did not see the reason to disparage them, as they would not come back to do any work, but I did not feel like it would be useful on my part to complain about quality of their work, as I was just strictly being factual about work that was completed or not completed. And that work was never completed, but basically it was added to the list of reductions strictly because I did not rebut that. So I want to be very clear that there were multiple issues that were, and yes, the work was being performed while we were living there. Originally, I was told that it would take them 4 days to do each of the rooms. So 4 days for the bedroom and bathroom, 4 days for the another bedroom and bathroom, 4 days for the living room, and 4 days for the kitchen. It took, we were almost at 3 months. The work was not even completed on the second bedroom. They wanted to start work on the living room, but I just wanted them to complete the work that was done on the previous stuff, just to completion, so we could actually move in and live in those rooms, as opposed to having a constant construction zone where we're trying to sleep, where we're trying to live, and all of that.
Thank you very much. A follow-up question?
Yeah, a follow-up question is, sir, previously you stated that there was an inspection in September of 2024, which appears to be after the appeal of compliance determination filed.
Yes.
Did you request the inspection?
So on the page before last, it says, however, there are a few items that will require an inspector to review to determine if the landlord is in compliance with the hearing examiner's order. An inspector will go out to the subject's premises.
So there was an order from the examiner.
Yes, and the inspector did come, and she took pictures of the condition, both of the apartment and...
Are you aware of the outcome of the inspection? I mean, was there a report, a copy of the report given to you?
There was not.
No, okay. All right, thank you, that's it.
Okay. Thank you very much, sir.
Thank you.
At this point, is there any public comment on this matter?
No speakers at this time.
Okay, great. So I'm going to close the hearing portion of this appeal and open it up for commission deliberation. Sure. I mean, yeah, I think if you want to start, Commissioner Topchian.
Yeah, this is for the legal counsel. Good evening, Ms. Martz. About the inspection report, so the examiner requested this inspection. I didn't see it in the packet. I don't know if any commissioners saw it. I wanted to know what was specifically ordered by the examiner to look into, and if we can get a copy of it.
Yeah, let me look at the entire file.
Thank you.
And if you guys want to keep deliberating, I'll circle back to that.
Perfect, thank you.
Commissioner, I'm not seeing anybody, but Commissioner Paris, would you be willing to share some initial thoughts?
Sure. I think that the documentation is pretty clear about the challenges that were faced by the contractors in completing this work. So I think as of now, unless somebody has a compelling argument, I'm leaning toward supporting the resolution.
Okay. Commissioner McCafferty, would you like to weigh in?
I'm also intrigued on that September inspection report. I think that will have some information, but also wondering like so if there is a scenario in the report in which the contractors can't do their work, how do we just get, like, what is do we have any, I don't know, how do we get the work done? So if we agree with staff's recommendation, is the tenant just out of luck, or like how does this work get done? Because I agree that it hasn't been done, but it seems like we're at a standstill, and so that's what I don't know, I'm more confused about or struggling.
I had a similar question, and I don't want to throw it onto council's lap, but in theory, I think the tenant would have an opportunity to file another request for a rent reduction, but I think there's a period of delay in which they're allowed to do that to kind of re-trigger the process of this never got done in the first place. Yes, there was a compliance determination, but it was resolved because of these other issues, but still, look, it hasn't been done. So I might be curious to know if we were to affirm what the time frame would be for the tenant to ask for another rent reduction on these issues that might not have been ever resolved.
Yeah, and let me go back to the inspection question. So those issues are not before us tonight. So the inspector, from what I can see here in the decision on, I'm looking at 602, is that it's mold growth on the walls of the bathroom, gaps on the bathroom tile, second floor, and repainting interior walls of the common areas. What I see in the file, I don't see that the inspector answered the questions as to those, but again, the issues tonight are not those issues. So the amounts restored, the $151 doesn't include any of those items. So that's an administrative issue we can look at on the backside, but the issues before you are the ones that I summarized at the beginning, which don't involve those issues. So I think in a perfect world, we would have had those. Actually, we wouldn't need to. The hearing examiner on the issues before us tonight determined that he was comfortable with the documents and information he had to make a compliance determination decision. And so the inspector was sent out on separate issues. So whether that came back, there's a different compliance determination decision that's pending or something like that, may be the case, but it's not before us tonight.
Thank you for clarifying that.
I have a question about that. Isn't the one, the cracked, let's see, the $10 rent restoration for cracked and peeling paint in the second bathroom tub, isn't that specifically what the hearing examiner, let's see if I don't remember which page this was, in his decision, it says basically we're sending out an inspector for that. Is that what you're saying? Or?
Correct. So not for the $10, the different issue. So he's restored in his decision the master bathroom window, $10, which was restored. Repair the mirror on the closet door, $5. Repair the master bathroom so that it doesn't separate. So they said there are two factors about why it will be restored. First, the sink was ultimately restored. Second, the respondent testified that they were blocked from doing the work. So they restored that as to $15. I believe that's a separate issue. Let's see here.
I'm trying to find the page where I'm thinking of that it specifically says about this item. I just had it.
603?
Yeah, 602, 601, 602, 603.
Oh, yeah, right. On 600, the second, I guess the first full one at the top, remediate the gap between the bathtub and the second bathroom so that any repairs results in no cracks or gaps. Is
Correct.
that different, a different issue than?
Yes, that's, an inspector will go out to look at those, and then if you look at 602 at the very bottom, However, there are a few items that will require an inspector to review to determine if the landlord is in compliance with the hearing examiner's order. An inspector will go out to the subject premises to inspect the following items, which are the three that I spoke to a few minutes ago. So that's why those items, the hearing examiner has not made a decision on those.
Oh, I see. The one that's in the appeal is the second,
Correct.
third
It's
one
a-
down. Okay.
Yeah, it's a separate one.
All right, thank you.
Commissioner Goldman, you wanna turn your special mic on and let us know what you think.
And wait for the delay to kick in. Yeah, so is the question then that since there was no evidence presented that we can see that from the tenant to counter the interference, so we had that evidence, right? And so I don't really see any in here, and so is the question then, because we can't find substantial evidence, then we're saying, do we agree with the decision?
Yeah, our job here isn't to rerun the hearing or the compliance determination. It's to answer the question, is there substantial evidence in the record to uphold what the hearing examiner decided as to the compliance determination? And even if you are 50% one way and 50% the other, you have to uphold the hearing examiner's decision if you find that there's substantial evidence there, even if you would have decided otherwise. And what staff is stating here is that we believe there is quite a bit of substantial evidence. I think it's pretty rare to have a contractor write a letter like that where they actually quit. And there was also testimony provided that they were prevented from going in and doing those things, and the constant rescheduling and those type of things. So you are correct that the lack of information provided by the tenant could have assisted their case either at the hearing or here. It being not in the record is why staff is recommending what it is.
Okay, thank you. And so I also, I guess to that end, want to bring attention to my fellow commissioners to the appeal here. I have, what page is it? I think it's 606, but it does say in here that where the tenant, I think in the first paragraph, he says, which left me no choice but to fix some of the deficiencies and inadequacies myself. So I am looking at that as evidence that seems to support the evidence that was submitted by the contractors.
Are you looking on page 606?
Yeah, 606.
Okay, so that's the appeal portion after the hearing?
Yeah.
So I think we're looking for substantial evidence at the hearing.
I see. Okay, so the note about fixing that wouldn't.
Yeah, as I understand it, that's after the hearing, so that's not the substantial evidence we're supposed to be looking at.
Okay.
That's my understanding.
Okay, thank you.
I was curious though, do you know how soon could the tenant reapply for a rent reduction on issues that were resolved against them strictly because of the alleged interference, and the issue is still there, and they can have someone come out and prove the issue is still there?
Yeah, let me look at that real quick.
Okay. My initial thought was a couple things. One, clearly this is a unit that has a lot of issues going on with it, and even the limited scope that's before us tonight is only a portion of the overall 463 rent reduction. So, and I'm hearing there are other things that are going on. So I would really encourage the landlord to make any restoration and service that is required, and certainly if they want to restore the full amount of rent, to make sure that these issues get addressed. But when we're just looking at substantial evidence standard, and we've got some pretty good evidence in the record that was at the hearing, a contractor quits, a contractor sends a couple of text messages, multiple reports saying that the contractor wasn't allowed to do the work. Even if that's disputed now, it wasn't apparently disputed at the hearing, and I think the tenant tonight kind of acknowledged that there were reasons why that wasn't disputed at the hearing, but we're left with what was at the hearing. Substantial evidence for interference. For me, I fall in that category, so I'm kind of inclined to affirm, but really hoping that the landlord continues to fix these issues, these larger issues, and that the tenant, if it has an opportunity to have any issues that resolved against it tonight, re-looked at down the road whenever that is appropriate. And on the $5 recount, no one's even mentioned that, but I'm inclined to adopt staff's recommendation on that. So the real restoration tonight would be 146 if we adopt the resolution.
Deliberating now?
Yeah, that was my deliberating. Go ahead, Commissioner Tobshin.
Thank you, Vice Chair. So quickly, it was important to me to understand the reason for the inspection and whether the inspection was requested by the examiner or ordered by the examiner based on those 13 items that are before us. Due to the request for compliance determination filed by the owner. So after reviewing everything and hearing everything here, I do believe that the examiner didn't err, and the determination that there is substantial evidence on the record that would suggest the tenant interfered in some way with the landlord's ability to complete the repairs ordered by the examiner, and it lists the specific work that was required to do and the interference that affected the ability to resolve these issues. So I cannot, I'm not here to weigh the examiner's decision. All I can do is look into the evidence and see if the evidence reasonably supports the findings of the examiner. And that's what the legal counsel is suggesting, the staff is suggesting, that yes, the examiner's findings are correct. And I do believe that the examiner reached the correct determination, and I'm prepared to support staff's recommendation. But I want to hear from the legal counsel in regards to that waiver. I believe it's 6 months, but you can clarify that. And we'll see what the commission may recommend on that, but I'm fully prepared to support affirm the decision as it's presented. Thank you.
And Vice Chair, I'm ready to answer that if I may. Sure. It would be 6 months from this evening before they could refile on that issue. And I would just remind the commission that as that's a regulation, the commission tends to like to waive those, but they should be few and far between. There should be a good finding of why that's necessary. I'll leave that up to you of whether those are necessary in this case.
Commissioner Kirby's?
Yes, so I think this is a difficult case in that clearly there was conflict with the tenant and the contractors, and it sounds like it reached a point where just so frustrating that they had to stop, obviously. But what I'm not seeing what I am seeing in the record is that several items were fixed by the contractor. A couple items created a problem that stopped the work. But there's nothing in here that says that the tenant, we often see times when the tenant won't allow people in the unit, they won't schedule appointments for them to come and visit. It doesn't sound like that specific issue is an issue here. And the only time I'm seeing where evidence is, or any indication that the tenant may have refused them from doing something outside of those two items that are very clear in the letter, is when the hearing examiner, in his or her own words, says the respondent testified that they were not able to get to these windows. So that doesn't tell me that they were, that tells me that of the list of things they had to do, they weren't able to get to those because these other things were taking up so much time, they stopped because they were just so frustrated. So I'm uncomfortable just giving a pass on the balcony that can mostly probably be done from outside of the unit, screens. That's just where I'm uncomfortable with is, I think there are consequences to the tenant's actions in this situation, the difficulties that were caused, but at the same time, there are some things that hopefully the landlord will just still continue to move forward and fix. But that's where I'm at. That's my problem, or my concern is that the balcony is just going to be left. When there were several other things that were fixed before, they just didn't get to the balcony. That on their list of things to do, they just didn't get there. And I can understand why this contractor wouldn't want to go back, but
So, Commissioner, you're suggesting that, for example, the balcony could have been repaired from outside without entering the unit, and there was no need for to arrange it with the tenant?
I guess I'm more suggesting that that wasn't an issue of conflict. It was like, we have a list of 20 things to do. We got to list number 15. There was a conflict, a blow up, we're done. So it wasn't that the tenant refused, we can't go back in time and try to redo it, but I'm just saying that it wasn't like he said, you can't come fix the balcony today.
But that, in my opinion, that would be kind of reweighting the evidence that was before the examiner.
There's no evidence in here that says that he denied it. It just says that according to the hearing examiner, but it's not clear on what that means.
I don't think we need evidence that he denied every single item per se. I think we have substantial evidence that there was a major blow up with the contractor, and that I probably agree with you. The contractor was like, I'm out. And that was allegedly caused by the tenant, and the hearing examiner found that. So I would caution about, it's substantial evidence and it's not re-evaluating what we think the hearing examiner should or shouldn't done. Is there substantial evidence to support it? I guess you're kind of making this causation.
I'm saying that there's not substantial evidence to show that he said no to the balcony. That's what I'm saying. There's no evidence that talks about him denying
not to the balcony, but there's substantial evidence you would agree that he interfered with work and that the contractor had to quit because of all the stuff that was allegedly going on.
Absolutely.
Okay.
But I also want to say that for the 10 items before or whatever, that they had no conflict over. The tenant and them had a conflict over two major issues. I see that as just human nature. Sometimes you have conflict with somebody, but you can still do other things. In this case, it's not a relationship where they may want to pursue, but that doesn't mean the landlord's just off the hook, because it's still his responsibility to fix certain things. And if the tenant said, no, don't come to my balcony, I don't want you touching it, or it creates the same problem, that would be a different situation. That's where
I think that's a little too granular, but that's just my view on that part of it. Because then we're going to be reevaluating every hearing examiner decision. Where's the evidence on this issue and that issue and this issue and that issue and this issue and that issue, versus at some point there has to be a an ability to have the hearing, look at globally what the hearing examiner did, which was, there's an issue here, the contractor quit, he wasn't able to get to these other issues, and he's attributing the inability to get to those other issues due to the tenant's interference. So anyway, that's where I'm at. But we should try to move this along because we do have 2 other items. So I don't know if other folks have anything else to add. Commissioner Goldman, I see you maybe wanting to say something.
Yeah, so I'm curious, where does that leave things? Because does that leave the landlord off the hook from having to actually fix?
No, I think it's
things,
6
or-
months. You would have to wait 6 months and then say, my balcony has all these issues. I want a rent reduction.
And it sounds like, Commissioner Kirby's, what you were saying is they didn't have conflict on, because we didn't see evidence of conflict on the balcony and some of these other things, but there was conflict on a couple items. And so then are we saying is that on the onus on the landlord to have maybe found somebody else to fix it? And that maybe the evidence shows that it wasn't necessarily the tenant, because the tenant wasn't, they're not saying that the tenant said, no, you can't come in and fix these items. I just want to clarify.
Struggling with.
Yeah, it could, because I'm thinking about that as well. That's why I wanted to clarify.
Is there a like an adjustment that you guys are thinking of making to the resolution that would cure that? Or, because if it, as a matter, we could straw poll and where we're headed to try and shortcut further deliberation. Because it sounds like we're mostly on the same page, except for.
Where are you, Commissioner McCafferty?
In short, I am leaning to just affirm staff's recommendation. I think that with the balcony conversation, the adjustment, could potentially be like taking the balcony out. However, I think that reminding ourselves that, like, is it reasonable? Is the decision to include the balcony in this list reasonable? And I think that it's definitely reasonable based on the evidence that we have, even if we might not agree with it. So again, in short, leaning towards just affirming as is.
Okay. Well then, what I'd like to do at this time is take a stab at a motion to approve resolution number 25-662, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming in part and modifying in part the hearing examiner's compliance determination as to application D-4804 CD1. So that would be the motion on the table. If there's a second.
I'll second it.
Okay. And then if we could do a roll call. So this is.
I'm going to make a motion to amend your motion or to replace it, whichever one is more appropriate. And that would be to affirm the hearing examiner's decision on number 2 and number 3. On number 1, it would be to reverse because of the error. And on number 4 and 5, to reverse. Those are the screens and the balcony.
Could you repeat it again?
Say it again.
Can you repeat the numbers?
Yeah, so on 1 through 5, it would be 1, we'd be reversing, which is, I think we all agree on. Number 2 and 3, affirming, which I think we all agree on. But on 4 and 5, I would recommend What's the opposite of reaffirming?
Commissioner,
Overturning.
the Commission Secretary, this is more of a rule of parliamentary procedure. We have a motion and a second. Doesn't that call for a vote? Or can
No,
it-
someone can make a substitute motion,
Okay.
and if they get a second on that, that one would come first, and if it fails, we would return to the
Okay.
original.
Okay. So
Second, yeah.
is there a second to amend as stated by Commissioner Kirpies?
Second.
Okay. All right, so we'll have a vote now on the amendment to the pending motion. So to be clear, my motion is just to affirm straight up the staff's recommendation. And then Commissioner Kirpies made his motion to amend, and it's been seconded by Commissioner Goldman. So on the amendment, could we have a roll call?
Commissioner Goldman,
Aye.
Commissioner Kirpies,
Aye.
Commissioner McCafferty,
No.
Commissioner Paris,
Nay.
Commissioner Topshin,
No.
Vice Chair Rory.
No. Okay, so the amendment motion fails, and we're left with the original motion with a second, and now we move to a roll call on that.
Commissioner Goldman,
No.
Commissioner Kirpies,
No.
Commissioner McCafferty,
Yes. Aye.
Commissioner Paris,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory.
Aye. Okay, so that motion passes. And I want to thank the landlord and the tenant for coming out tonight. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. So thank you very much for your time this evening. If you want to stick around, you can. What I'd like to do, if possible, is move on to the next substantive matter and then take a break, if people can do that. Okay, let's move then forward with the second resolution on tonight's agenda, which is resolution number 25-661. This is for the property on Norton Avenue. And I'd like to ask for Commission Counsel to give us a report on this item.
Thank you, Vice Chair. Again, my name is Kellen, Legal Counsel of the Rent Stabilization Commission. Our second appeal tonight is for D-4889 at 8220 West Norton, unit number 15. This matter is not a compliance determination. It is a standard appeal of a hearing examiner's decision.
Resolution on tonight.
Okay, let's try that again. All right. So in this matter, there was a hearing examiner's decision granting a rent decrease application. As in the previous appeal, I'm going to defer to the staff report because there are 17 items on that matter, 16 housing service matters, and then a determination of maximum allowable rent and excess rent paid. The appeal in this case is filed by the landlord. They have argued that the decision is clearly in error and that it is contrary to specific provisions of the RSO or state law. The matters before you tonight are whether the maximum allowable rent, or MAR, was properly determined by the hearing examiner, whether the landlord accepted and retained rent in excess of what is permitted by law, and whether there was a proper determination regarding the discontinuance or substantial reduction of housing services. Staff believes that the MAR was properly determined, excess rent calculation was properly determined, and that there was a proper determination regarding the housing services. In this matter, the tenant has lived at the property since 2004. A hearing was held in May of 2024. Both parties attended. I'm going to defer again to the staff report about those findings due to their length, which is on page, it looks like 14 to 16 or 17 of your packet, a decision was issued on May 16th, 2024, which granted a rent decrease on 15 issues. 2 were found not to have been met. There was a total reduction in rent of $276 for the tenant, and neighboring tenants were issued $78 per unit for the reduction in common area issues. The common area issues at issue were the on-site manager and parking area repairs. Landlord then filed a timely appeal. As I said, claiming it was clearly an error and contrary to specific provisions of the rent stabilization ordinance or state law. A summary is that the landlord has argued that the property was properly registered with this city, and that therefore the rent increases issued were proper. Landlord also argues that the property complied with the RSO's housing services requirement, and that they've had a property manager in place that meets our city laws. The landlord also argues that they've repaired the housing issues, with the exception of the bedroom closet doors, which have not been fixed. Landlord has argued that the tenant has not permitted this repair or replacement. And so the questions tonight are, is there substantial evidence of the record supporting the hearing examiner's determination regarding all of the various housing issues or housing services? Is there a substantial evidence in the record as to the MAR and the refund of excess rent? So the landlord's appeal argues that all of the housing service has been rectified with the exception of the closet door. These issues should be determined through a compliance determination. Once that request is received, city staff can review that for restoration of rent if appropriate. As to the resident manager, staff does not find that the landlord's arguments hold water, and again, that this is better issued through a compliance determination if they do believe they have a manager in place that meets our RSO requirements. They did submit a very blurry photo, but it did not seem to prove their point. Lastly, as to the determination of the MAR and excess rent, MAR was determined by the hearing examiner to be $1,100 due to the landlord's failure to re-register the unit upon vacancy as required by the RSO. Therefore, any amount charged over $1,100 would be excess rent needed to be refunded to the tenant. The statute of limitations on that is 3 years. The landlord did submit a re-registration form, however, it was blanked out, and staff compared that form with the re-registration form for the prior tenant and found that they were substantially similar in the areas that we could see. So staff felt that that was a prior document, and there is nothing that was in the record that was submitted that showed the tenant's name on it. So we do believe that the unit was not properly re-registered. And then the hearing examiner did order a refund of $8,516.84. Staff believes that that was the proper determination. There is a spreadsheet that the tenant provided in their initial request for rent reduction that had a higher amount. However, staff believes that the hearing examiner correctly calculated the overage. That's because there were a few items in the tenant's calculation that should not have been included, and that includes the registration pass-through of $6 per month, which should have been excluded. So there is about a $500 or $600 discrepancy there, but we believe the hearing examiner correctly determined the amount. So in conclusion, staff recommends that the commission affirm the hearing examiner's decision and adopt resolution RSC 25-661. That concludes my report, and I'm available for questions.
Go ahead, Commissioner Kirby's.
I have a quick question about the $6. So even though that wasn't re-registered, the landlords are still paying the city for the unit, correct? It's just so that's why they're not just pocketing the $6. I mean,
Correct.
that $6 would be going to the city. Okay, thank you.
Yes.
Commissioner Toche.
Just very quickly, these redacted documents that are start on page 32 and through page 53. These are landlord submitted documents, right? That's what you referenced, the unit registration.
Correct. Nothing redacted that you see was done by staff or legal counsel.
Okay, so, all right, okay, so
That's how it came into the office.
right, that's why I wonder if this is, if this was requested through CPRA, so then the city should have had a original copy, I would assume.
This was submitted from the landlord, so
From
this
the
is
landlord.
how we received it. None of this, from my knowledge, would have been with the city
Okay.
otherwise.
Thank you, sir.
Any other questions? Okay. At this time, I'm going to ask the representative from the landlord, who's the appellant here, Ms. Sarah Lathrop from Cirrus Asset Management. She's going to speak. Ms. Lathrop, can you hear me? We're going to get our Zoom working here in a second. Just hang tight. If you can hear me, Ms. Lathrop.
Chair, if I may, we also have an additional representative who has since joined us in person.
For the landlord?
Yes, and he'll be speaking on their behalf.
Okay. Oh, yeah, that's fine. So Ms. Lathrop is not going to be speaking, and instead we're going to have this gentleman. Could you please state your name?
Austin Monroe.
Okay, and your relationship to the landlord?
I am a district manager for Cirrus Asset Management.
Okay, great. And so you're going to have 5 minutes total to speak. You get a chance to speak after the tenant. So whatever of the 5 minutes you don't use in this initial round, you'll have for your second round.
Very good.
And you may begin.
Thank you all for your time. Yeah, essentially I just wanted to run through the list. We have some dates here regarding the replacement of the carpeting. The flooring was replaced with a vinyl click plank flooring style. That was on June 24th of 2024. We replaced the flooring in the kitchen and bathroom as well on 6/24. The remediation of the sagging popcorn ceiling was finalized as of May 31st. The bedroom blinds were replaced as of June 22nd. Of course, all of the dates are 2024. The bedroom closet door was actually repaired. That was repaired as of August 29th, 2024. The pocket door was completed on June 13th. For the toilet, we had a repair done on April 22nd. The repair did not hold, so then we replaced the toilet on May 16th. The bathroom fan and cover were replaced on 6/13. Let's see, cracks and paint were completed. I believe that was also on 6/13. I don't have the date in front of me, but I think that was on the same date. Bedroom door was completed on 6/13. Water retention on the balcony, we had our contractors address that on 6/26. For the on-site manager, we have Ricardo Aguilar in Unit 14. He's been like the point of contact on-site responsible party for some time before we took over management as well. For the area, the holes in the parking garage, in the original hearing, the hearing examiner acknowledged the photo, and that was like a plumbing access point. So there's like a square cutout where there are pipes that go up. So that's not, something that we would consider needing to be patched over. Regarding the recycling bins, those are the property of Athens Services, but they have not been removed. We still do have recycling bins on site. The security lighting next door is, of course, not something that we can personally control. And then the maximum allowable rent, you spoke to the registration form. The dates do align with the resident's tenancy. And we show that the city did receive the document and acknowledged it on May 4th of 2004. So that's where we would argue that the decision is in error, and we do believe we're in compliance with the requests made. That's really all I have for you guys.
Commissioner McCafferty?
For the registration, you said the dates align. Does the name of the tenant align? the current tenant with that registration form?
My understanding is that we received the registration from the city. So of course we were not the management company at the time, so I don't have the original document. We received the document from the city.
And you received it redacted from the city?
Correct. That's my understanding.
Okay.
I didn't personally, I didn't personally receive it, but our team did.
Okay.
Yeah.
Commissioner Topchin?
Yes, good evening, sir. As a follow-up to that question and the question that I asked legal counsel, so in regards to the re-registration form that is redacted, you're saying that you obtained this from the city, not you personally, not your company, but the company before?
Company did, but a colleague of mine.
Or your company?
Yes.
But
yeah.
okay, different person.
Correct.
Was it, do you have any information if it was obtained through official CPRA request, California Public Record Act request, which requires to fill out a certain form, identified what document you're requesting from the government agency, in this case it's the city of West Hollywood, paying certain fees, I guess they're involved, in order to produce a copy of a document that is a public record. Do you recall, do you know if the form was filed like that?
I do not know.
You don't?
I don't.
Okay. All right, I guess that's what I want to have it on the record. Thank you.
I had one quick question. Are you familiar with the compliance determination process after there's been a rent reduction, how you can ask the city to come back out and look at the items that you think have been fixed, and then they can review that and tell you whether they're going to restore the rent?
Yes, yes.
You're familiar with that, okay. And is there any reason why a compliance determination, because on the list of items, you were mentioning a lot of dates. This has been fixed here, this has been fixed there.
Correct.
Why hasn't a compliance determination process been initiated, or do you know?
We were waiting for the hearing decision after the original hearing. When we got the decision, we filed the appeal, and my understanding is that we can't apply for a compliance determination until this process is completed.
Okay.
Yeah, that's my understanding. If it's incorrect, please do let us know.
I'm sure they will. I think you can have just a seat real quick, and you'll have a chance to come back. Oh, go ahead, Commissioner Krupe.
Just to follow up on what Commissioner Topchin was asking about the form. Is it so? Did you ask? Did the company ask for the form from the city for this specific purpose, or when you took over management of the building, it was part of your process to ask for forms for all of the units, or do you know?
That I can't speak to specifically.
Okay. Thank you.
Thank you.
Okay, so at this point, I'm going to ask the tenant to come forward, Mr. John Lown, or Lown? Lown. You're going to have 5 minutes, but you get just one opportunity, so use as much of your 5 as you'd like.
All right, thank you very much. All right, my name is John Lown of City of West Hollywood, and first of all, I would like to thank the commission for their time tonight. I know it can be kind of tedious, but it's a wonderful thing that this forum exists, and it's part of what makes West Hollywood a great place to live, in my opinion. Been here a long time. But getting back to business, I'd like to split my time into kind of two things. One's going to be short because it's pretty much been addressed. I'll start with briefly touching on the rent reduction, then I'll move over to the MAR and the overpayment of rent. And as far as the rent reductions, items 1 through 16, as noted, basically all the evidence presented by the landlord is even dated after the hearing. It's just it doesn't really apply, in my opinion. So I'm leaving it at that because I don't really have anything else to say about it. As far as the overpayment of rent in the MAR, actually I'd kind of like to start, I've got a little theme going, so if you give me latitude, I'd like to read a couple sentences from the Veritas website, and Veritas is the ownership of the building itself. And it reads, Veritas Investments is an experienced real estate management company that specializes in operating mixed use and multifamily and retail properties in major West Coast markets. With nearly 250 buildings and 5,600 apartments across the San Francisco Bay Area, Los Angeles and Seattle metro areas, Veritas Investments is one of the West Coast premier multifamily operators. So it's clear that when they purchased the building a couple of years ago, this wasn't their first rodeo. They've been down this road before. And it's difficult to me to believe that when they purchased a multi-million-dollar property, they did not do business 101 of verifying tenants and the set rents per tenants, because that's income stream 101. I mean, that's why you're part of the reason you're purchasing this property. So as it turns out, I found out that I've been overpaying rent for 20 years now, and I can only conclude that Veritas did find that problem or that issue when they did their due diligence, because I have to assume they did, and they decided it was in their financial interest to simply ignore it and move on, because at that point in time, I was paying 22% over what the examiner decided the MAR should be, which now it's up to 28% over, because I'm still paying that increased rent. So circling back in conclusion, if it's within the scope of the commission, which I'm not sure because first time doing this, if you do uphold the decision of the hearing examiner, I do ask two things. One is that since Veritas obviously has resources with all the properties and everything, that instead of applying the overpayment of rent in a long extended credit system, which will take months or possibly over a year, actually have that reimbursed to me, because in my world, that's a fair amount of money that I should not have been paying. And the second part would be that since this, in the 7 months since the appeal was filed, I've still been paying the overpayment of rent, but that is not addressed in the hearing examiner, so I didn't know if that's something that can be addressed here or I have to go forward. But if it's within the scope of you guys, I'd appreciate that being tacked on, because I've been paying for 7 months of that extra bit. So that's it in a nutshell. Thank you again for your time, and I'm available for questions.
Great. I think we probably have a few. No?
Well,
Okay, I have a question real quick.
Yes.
I wanted to ask you, just so I understand the sequence of you becoming a tenant at the unit. There was a document on page 115 of our packet, which looks like a statement from you kind of explaining the history of how you got into the unit.
Correct.
And I just wanted to make sure I understood correctly. Your tenancy officially starts April 1st of 2004, is that right?
That's per the original lease that is also submitted into evidence.
Right, okay. And like about a month before, in March of '04, you had responded to this Craigslist listing to see if anyone was interested in taking over the lease, and that's how you kind of came to learn about the tenant, the unit itself. And the prior tenant, immediately before you, was someone by the name of Catherine Wood or Catherine Woods. That was your recollection?
Yeah, I met her one time when she showed me the apartment, because for whatever reason, she wanted out of it.
Okay, and then you've taken over since. And do you ever remember signing any document around that time that would have been a unit re-registration?
I did not, and I keep everything. I have the original lease. I don't have that in my records. I can shed a little light preemptively, kind of speed things up with that, with the document that was submitted by the landlord that's redacted. If you'd like me to now, I can kind of explain what that is.
Well, I think we kind of, you're welcome to, I think we'll just answer my question directly if that's okay. But
sure.
The document that you're referring to, it has a date on it, and this is page 324 of the packet. This is the unredacted version. And it says that this was signed apparently by a Catherine Randolph Wood on March 27th of 2004. So that would have been just a few days before your tenancy started. But you weren't the signatory there. The previous tenant, Catherine Wood, was. Is that your
Correct.
understanding?
I had no knowledge of her. I've only met her through the Craigslist listing.
Okay. Okay, those were my questions. I don't know if anyone else has anything. You okay, Commissioner Paris?
Yeah, I just wanted to clarify, there are a number of items that I'm not sure are resolved based on the packet. The asbestos test was completed at some point?
I'm sorry, go ahead.
The asbestos test was completed for the ceiling replacement?
I did not get the actual report. I got a verbal from the management company that it was performed and came back negative for asbestos.
And they finished that repair?
Correct.
Okay. And then there was something about the toilet. This may have been answered by the landlord. Sorry, this packet is enormous. That the toilet was to be replaced, but there was something about you understanding that they were not able to complete that repair?
They did complete that repair again after the hearing.
Okay. Those are my two questions. Thank you.
Any other questions? No? Okay, great, sir. Thank you for your time. You can have a seat.
Okay, thank you very much.
And I'm going to ask the representative for the landlord to come back up and have Commission Secretary remind him how much time he has.
2 minutes and 8 seconds.
So the floor is yours.
At this time, we don't have a major rebuttal. I do just want to address, I don't know that Veritas Investments, overall portfolio is relevant to what we're here to discuss today. So just don't want to muddy the waters too much with that. Regarding the specifics of the purchase of the property, this unfortunately would have been before our tenure there. We took over management of the property as of September 16th of 2023. I believe the property would have been purchased in like March or so of 2021. So I don't have the details on that. Yeah, just reiterating that we do hold that the registration form, the dates do align with the time frame that the resident moved in. So we would hold that the unit was properly registered. And that's all. I just thank you all for your time. If you have any questions, I'm happy to answer.
I think we're good at this time. Thank you, sir.
Very good. Thank you.
Thank you. You can have a seat. Was there any public speaker on this item?
Not at this time.
Okay. So then I'm going to close the hearing portion and open the deliberation.
Question for legal counsel.
And I'm going to kick it over to Commissioner Topchian to lead us off with a question for counsel.
I'm asking a lot of questions today, Mr. Martz. Regarding the reimbursement, just wanted to clarify, since the question was asked, but for our understanding, there are a couple of ways, I guess, through a rent reduction to reimburse the amount owed, or maybe a direct reimbursement, giving a cash or check on order. If it's a rent credit, can the department direct, or the commission, that the reimbursement will be returned in a kind of a larger amount, like amount of the whole rent? So that would be, in this case, 8 or 9 months to pay off, instead of doing like $50, that may take like 20 years.
Yes.
So, yeah.
So the commission is relatively limited by the regulations of how they can set that up. So it's more dictated, and there's more power to the hearing examiner to make that order. And so if we look on page 101 of your packet, which is the original decision, on decision order number 5. The landlord is ordered to reimburse the tenant 8516 and 84 cents. Must be repaid by July 31st, 2024, which is after the appeal is filed. If an appeal is filed, that's put on hold. And then if the tenant is not refunded that amount, they may reduce their forthcoming rents until the amount owed by the landlord is accounted for. So that is what, if you uphold the decision, that's how it would go back. So the tenant would be able to, and the MAR, if you find it so, would be $1,100. So effectively, they would pay $0 for approximately 8 months. I'm not going to do the exact math there. The parties do have the ability to go to small claims court in these cases. That's outside the purview here, but I know some have done that in the past when they're larger amounts like this.
Thank you, sir.
You're welcome.
Clarified everything.
I have a follow-up for that. For the rent that the tenant testified he was paying from the hearing until now, that goes over this 8,000 number, how do we address that?
That is outside of the purview of this appeal. The tenant would have to file something new. Or, if you do find in favor of the tenant tonight, the landlord can, see the writing on the wall and do the right thing. But it is outside, because what we're effectively doing here is looking at what the hearing examiner decided in a box, right? And so you're basically, how I describe this commission to people is the hearing examiner is like a baby judge, and you're like in a baby appeals court. So there could have been something that happened after the hearing was decided that means that his rent is now $3 million a year. We don't know. And so that's why we can't really look at that finite few months since we've been here, even though it makes sense that we would want to.
Go ahead, Commissioner Kirby's.
Just to follow up on that, so that the tenant and landlord know, is there a remedy for those situations? Would it be like the tenant taking legal action on their own, or would they come back to the city to file
They would file another case,
over
rent reduction and MAR determination with the city. They could submit this decision as evidence in support of that. Anyone can go to small claims court for anything. So, yeah.
And it seems like maybe we've already thought about this, but I can save that comment for later. Thanks.
Do you want to kick us off with deliberations, Commissioner Kirby's? I was going to have you start.
Yes, so I will be, of course I want to listen to my fellow commissioners, but I'm pretty much in support of the hearing examiner's decision. I appreciate that the management company has taken action and resolved, sounds like, all the issues or most of the issues. But as pointed out earlier, the solution for that, or the remedy for that, is to do the process of compliance determination, which I do understand in your case, it may have made more sense for you as if you disagreed with that $8,000 large sum. That's why you appealed rather than just going through the other process and resolving all this. So I can understand that. But I wonder too, I guess my other question for counsel when he's got a chance. But otherwise, on the merits of this case, I do agree that the hearing examiner made a correct decision. I would vote to affirm, and same with the overpayment of rent. I'm glad that I heard the testimony from the management company tonight, because coming into this, I was thinking that I just had this feeling that somebody was trying to trick us or trick the city or to pull one over on us. It sounds like that was not the case, that they had this form. This is a unique situation where we've got the tenant replacing another tenant at the very beginning, but that doesn't comply with our laws still. The management company still has to register, and I do understand why you all may have thought you did in this case, because if you received the document redacted like that. But I guess best practice would just be to always file for new registrations, I guess, whenever you take over a building in West Hollywood, unless you have somebody's name on file. But I did have a question for legal counsel. Could they have, excuse me, because it sounds like they were working to comply with this regardless, could they have just appealed on the $8,000 and got a compliance determination on the other stuff? Had they made that decision at the beginning?
That's a question that Mr. Kessinger and I need to look at a little bit more closely, and we can try to get you an answer tonight, but...
I mean, it won't affect them in this
correct,
case, but
correct.
I'm just curious for future.
But if we don't, for now, we will definitely bring something back next time.
Thank you.
Commissioner Goldman, you have thoughts on this one?
So I'm also inclined to want to affirm the hearing examiner's decision based on what we have in front of us.
Okay. Commissioner McCafferty?
Yeah, agree. It's clear to me to affirm.
Okay. Commissioner Paris?
I'm curious about your all's thinking on the re-registration of the unit, because the previous tenant gave up, like, sub-lease their unit to essentially their current tenant, and they took over the lease. Is the thinking that the fact that this new registration was not filed the basis for which we're awarding the MAR?
My thought on it was there was a new lease, and that was part of the packet starting. And what it looks to me happened is that for whatever reason, the landlord had the outgoing tenant sign a unit re-registration on the last days of their tenancy, but the new tenant didn't know about it, apparently, didn't sign it, and that form wasn't, it didn't apply to the new tenant. So it looks like there was an effort to try to re-register by the landlord, but they got the signature of the old tenant, and it wouldn't apply here.
Okay.
So that's what I think happened, and then I agree. Initially, I was like, is somebody trying to like tell us that it was re-registered, and then we've got the proof? Because if you compare in the packet, page 324, which is the unredacted version, to page 32, which is the redacted version, it's pretty clear that it's the same form. So that's how I'm comfortable surmising that it was the old tenant who signed it on the final days of their tenancy, and the new tenant didn't. So that's just the rule we have here in West Hollywood. And I will say, as I understand it from the people who've been on this commission longer, it used to go back to the start of the tenancy. So in this case, it only goes back 3 years, but this landlord could have, under an older version, had to go back to 2004. So we're not doing that tonight, and that's not the current law. But I'm comfortable upholding that portion, and on the adjustments, I thought there was substantial evidence. So I'm also inclined to affirm.
Very briefly, so I agree with with fellow commissioners that you're presiding chair. Based on the statements from the management company or representative, so I see the reasonable company, and they are, at least what I heard is the intent is obviously to do the right thing, to act in good faith and comply with the requirements of the ordinance, and which is one of the first requirements. I mean, number one requirement from the time when the RSO was enacted in 1984, was basically to re-register the units, because that's how the department, the city, in a way controls the rent. So the evidence shows the evidence before the examiner showed that the landlord didn't meet that requirement, and so therefore I would agree with the findings of the examiner, and I'm prepared to support staff's recommendation. Thank you.
Do you have anything you want to add further? Okay. At this point then, I'm going to make a motion to approve a resolution number 25-661, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D-4889. Is there a second?
Second.
Okay, I'll recognize Commissioner Paris's second. Thank you. To the other end of the aisle. And we'll do a roll call vote.
Commissioner Goldman,
Aye.
Commissioner Kerpes,
Aye.
Commissioner McCafferty,
Aye.
Commissioner Paris,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory.
Aye. Okay, great. So thank you very much. As stated before, if the parties have, this motion passes, and if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And so thank you, gentlemen, for your time. You're free to hang out or do what you want for the rest of your evening. We have one more matter for this evening, but I would like to propose a 5 to 10 minute stretch break. So my understanding is it is currently 8:41, so let's try to be back here at 8:51.
And Chair, I just remind everyone not to speak about the next item, either with people in the audience or with each other. Thank you.
Great. All right, we're in adjournment until 10 minutes.
And before they leave, if they do leave, I just appreciate both the parties' cooperation with each other and civil interaction throughout the process. It sounds like you guys have been working together on resolving these issues. Thank you.
recess, and we are going to pick up where we left off, which is finishing the appeal portion of our calendar. And right now we have our last appeal for tonight, which is a compliance determination, D4689CD. And this is for the property on Edinburgh Avenue. Going to pick up where we left off, which is... And I'll ask Commission Counsel to please give us a report.
Great, thank you very much. And for the last time tonight, I am Kellen Martz, legal counsel to the Rent Stabilization Commission. This is our third and final appeal, which is D-4689 for the property located at 1021 North Edinburgh Avenue, number 8. One moment, please. All right, and this is going back to a compliance determination case. The appeal tonight has been filed by the tenant in this matter. The decision restores portions of the MAR for the subject property. The original decision dates back to September of 2022, which reduced the MAR for several units on the property. That decision included a reduction of $120 for each applicable unit due to the removal of a common area washer and dryer. A subsequent compliance determination restored the $120 rent reduction for affected units after finding that the landlord had reinstalled the washer and dryer in the common area laundry room as required. The tenant has appealed this decision, asserting that the compliance determination was not supported by substantial evidence. They have disputed the adequacy of the return of the washer and dryer. The tenant alleges that the laundry room is restricted, the appliances may not be functional, and they were not actually in place on the date the landlord stated they were for the compliance determination. I want to note that the original hearing application was filed by a different tenant in the building, but because this is a common area issue, the affected tenants, any one of them can file an appeal if they disagree with the compliance determination decision. In this matter, after reviewing the evidence, staff recommends affirming the compliance determination in its entirety. So the tenant has resided in, the staff report's a little different. We don't have dates because they were not in the original decision, so we just know they lived at the property at that time. We don't have a date that how long they've lived there. There was a rent reduction for a number of tenants for the common area issue. Several of them did opt out, which is their right. Several years later, on May 31st, 2024, the landlord did file a compliance determination request asserting that the washer and dryer had been reinstalled. They submitted an invoice for the purchase of those items and submitted a photograph showing them in place and plugged in. A compliance determination requested that a city inspector go out to inspect the property to verify the washer and dryer was in place. The inspector's report includes photographs, which do confirm that the washer and dryer were properly installed and plugged in, the buttons were working, and they were in used but good condition. The report notes that the keys to the laundry room had been made available to the tenants, but that was according to the landlord. The city inspector found access to the laundry room was open without a key. Either the door was unlocked or it was actually open. Based on this evidence, the compliance determination found that the landlord had complied substantially with the original order's decision to reinstall a washer and dryer. The compliance determination therefore restored the rent of $120 for the affected units. The landlord submitted an invoice for the purchase of those items along with photos. As noted in the staff report, the city inspector did go out there, including 19 photographs and documentation of what they found. The tenant has objected to things that are outside the scope of the appeal, including cleanliness and access. The original decision only required the reinstatement of those devices. So cleanliness and access would be separate issues that would be under a separate rent reduction request. Tenant also states that the laundry units were not in place when the landlord said they were, providing a photo showing the laundry units outside of the laundry room. That document of photos was dated July 10th, 2024. So based on the substantial evidence requirement, staff does believe that the compliance determination was correct, that it's supported by substantial evidence and is not arbitrary or an abuse of discretion, and therefore recommends adoption of Resolution RSC 25-663, affirming the compliance determination decision. That ends my report, and I'm available for questions.
You'd be remiss if you didn't ask a question.
No, just a quick question. It caught my attention. So the inspection date was July 19, 2024. Because it's just a matter of correcting maybe the procedural background of your report shows July 10, 2024, but we have a photograph from the 10 of July 10, 2024, which shows the appliances are unplugged. So just wanted to make sure it's the record is corrected. That's pretty much it. Thank you.
Commissioner Kirby?
My question is just, so when does I see that the determination was issued on August 5th. Does it date back to when the request for compliance determination was filed, or when does
Correct. The filing date of the compliance determination from the landlord in this case.
So it would go back to May 30th?
That's correct.
First, okay. Thanks.
You good, Commissioner McCafferty? I see a quizzical
I think
look.
I didn't hear you. When did the inspection take place? The 19th or the 10th?
I will look at that and tell you the...
I think the 19th. Is that right? I think that's what Commissioner Topchian's comment was trying to clarify.
Okay. I didn't know if I misheard the answer, but it seems like they're looking it up, so sorry.
You can check the page 655 and 656. That's the inspection report.
Yes, it does say inspection was completed on 7/19/24 by Adriana Borges, Rent Stabilization Information Coordinator.
We're good? Okay. So at this point, I'm going to ask the tenant, Miss Lorraine Popielarski, who I think is going to be joining us by Zoom. Let us know, Miss, if you can hear me.
Hi, yes, I'm here.
Hi, Lorraine. Thanks for joining us. So you get 5 minutes to speak, and you have 2 turns. So whatever you don't use in your first turn, the remaining 5 minutes you get to use for your second turn.
Sure thing, no problem. I'll be really quick. We've had ongoing problems with the cleanliness and compliance with this landlord. He has claimed that this laundry room was usable, and when you say cleanliness and cleanliness meaning there was exposed mold, there was broken glass, there was backed up sewage in the sink of the laundry room. So we're not just talking about cleanliness, we're talking about safety and sanitation. And that's why when he claimed that it was usable and safe, that's why I filed the appeal. And also, I'm fine with reinstating having that laundry back, but I was just wondering, because we did not have services for the month of July, if it would be retroactive for August or half of July. So that's my only question is, the credibility of the landlord when he says it was available on the 31st was incorrect. And I just wanted to know what would be fair in order to have it reinstated, because as I show in the pictures, you can see the condition of the laundry room. There was exposed ceilings, there was water damage. I mean, it was in really bad shape. And that alone, was very safety concerning. It was done, I think, by the 19th, but it certainly wasn't done by the 1st when they reinstated that rent to be put back in. So that's my only question, is what would be fair to have the rent reinstated moving forward? Thank you.
Okay. Are there any questions? Commissioner Paris?
I was curious about in the packet under the evidence, there are pictures of the window that seem to point out mold inside the laundry room, but I'm unclear as to, from the perspective of this footage, is the mold on what looks like the drywall that's inside the laundry room, or is the mold on the glass?
It was a piece of wood that was inside the laundry room, and that was just one portion of mold. I don't know if you can see multiple pictures of the water damage and the exposed ceilings that had holes in there. So it was throughout. That was just one example on the outside. Because I don't think we even had access to get in. I don't remember. I think it was broken into by homeless people, and they were kind of squatting in there as well.
All right, thank you.
Mm-hmm.
I had one quick question. I think, did I hear you correctly that as of July 19th, it was your understanding that the washer and dryer were had been reinstalled?
They'd been reinstalled. I don't know if they were working. They were never tested. There is another tenant that's in here, Andre Santinello, who lives in the building. He's welcome to have some time. I don't know if that's allowable, but he might be able to attest. I know for sure he didn't have a key either, so he did not have access to the laundry room. But they did not test to see if the units were actually working.
Okay, well, if he wants to do public comment or something at the end, I think he'd be available to do that.
Okay.
Okay, Lorraine, I'm going to have you just hang on for a minute, and we're going to hear from the landlord, and then you're going to have your second turn.
Okay, thank you.
Okay. And so at this point, I'm going to ask...
Chair, the landlord is not present.
Oh, he's not?
No.
Okay. So we are not going to hear from landlord. The other person on the call is not the landlord?
No, that's seems to be a tenant in another unit.
Okay. Okay. All right. Well, Lorraine, the landlord is not here, so I don't know if you have anything further you'd like to add, but this will be your final opportunity. Oh, sorry, you want to unmute yourself.
You know, I know this is sort of siding from the laundry, but I have to say that we have been tenants in this building for a long time. We've been harassed. We've been taken to court. He's doing everything in his power to get us out because we're all rent control. And he's now, you know, he's taken away our laundry, and I don't know what he's trying to do now. He's trying to renovate the rest of the units to try to sell the building. But we've had a very tumultuous battle trying to just live peacefully in our units. There had been a couple cases before with this person. I don't know if some of you remember, but it's not been a pleasant road with this landlord, and he just doesn't do the right thing anyway. But
Okay. Thank you very much.
thanks.
Is there any public speaker or anyone else who'd like to come up as a public speaker at this point? This is anyone else's opportunity on the line.
Hello.
Hi, sir.
Hi. Yeah, I'm the other tenant.
Could you briefly state your name?
Yeah, Andres Santaniello,
Okay, and what unit are you in?
number 6.
Okay, and for public comment, they get 3 minutes. So, sir, you can
Okay.
say what you would like for 3 minutes.
Sure. Yeah, I know this is a common area issue. So I mean, what Lorraine said about the laundry room. I mean, I completely agree with her. I mean, the landlord never gave me a key, so I cannot say that I've seen the laundry room working, but I saw one day one homeless guy coming out of the laundry room, and it was a completely mess inside from what I see because the door was broken. And after that time, I mean, I never seen the laundry room working. So, and I never seen anyone like doing laundry or something. So I'm not sure if it's working, but I don't know. I don't think anybody's using the laundry room right now. But that's it pretty much.
Okay, thank you very much for that.
Sure.
Okay, so I'm going to close the testimony portion of the appeal, and we will start the deliberation and question portion.
Chair.
Yes.
Legal counsel. So what is the date when the rent's supposed to be restored and the tenant should pay the restored rent?
It would go back to August 5th, 2024, the date of the
From the
compliance determination.
issued. That's
Correct.
the day when the rent will be restored.
Yes, depending on yes, it would go back to them.
Okay. So prior to that date, the rent is reduced.
So an appeal of a compliance determination does not stay the decision of the hearing examiner.
Okay. All right. Thank you.
I'm confused.
Go ahead.
I'm confused about the date. So what date? Because you said August just now?
The date of the compliance determination decision, which is August 5th, 2024.
Okay. So not the May 31st, when they filed it.
Correct. I looked it up for the.
Okay.
So, no, what we were looking at is what are we looking at for when those were reinstalled, which was the May date, but the decision goes to the actual date.
So the rent. So it's really almost irrelevant what was happening on July 10th, because
Correct.
July 19th is when we have record of it, and
Correct.
it wouldn't. That proves that August 5th or August 5th is when the rent would be reinstated.
What you're looking at is what the landlord said on the date they submitted it, which is May. An inspector didn't get out there until July, but what the July inspection is doing is trying to say what is in place. You know, it could be 2 days that it takes for them to get out there. Obviously, you know, it takes a while to get through the process, but what legally we're looking at is, was that item in place on the May date when the landlord filed this request? The inspection doesn't change that we're still looking at what is there in May. They're just providing additional evidence to support or not support that May request. And then the legality of when the rent reduction or the rent restoration goes into place is the date of the hearing examiner's decision.
Thank you.
You're welcome.
I'm going to try to.
On our paperwork, it
Oh, I'm
says it
sorry.
wasn't-
I'm really sorry, but we're not allowed to have further comment at this point. That's just the rules of how the procedure works. I apologize. I would do that for any party. Commissioner Topshian, would you lead us in your thoughts?
So I think what I heard from the tenant is the point that they wanted some sort of a reimbursement until July 19th, until the date of July 19th at least, when the inspector conducted the inspection and verified that the washer and dryer looked connected and on, and everything was restored per the report. So if the compliance, if the restoration of rent date is August 5th, 2024, which is the compliance determination, when the compliance determination issued. So I think then this matter is covered, so the tenant is being reimbursed for the time, any time in July, and even more, I would say. So that's what the logic that, that's why I asked the question. And I think the tenant is being reimbursed. Tenants are being reimbursed for that time based on the inspection date and as a subsequent based on the compliance determination date. Thank you, Chair.
So you would vote to affirm? Your tentative is to affirm?
Yeah, if you want to ask a question, so that's fine. Yeah, I can talk about it. So I think that, yeah, findings are correct. The examiner's decision is correct, and definitely I will affirm I will vote to affirm the recommendation of the staff.
Okay.
Thank you.
And Commissioner Paris?
Yeah, I wanted to test the waters. Like, it sounds like the determination is pretty cut and dry on the facts, but I want to make sure that this is the final appeal on this issue, and the tenants would have to wait 6 months to file for a new issue to resolve the out-of-scope matters? No?
I don't think so. Out of, like, cleanliness, that's a new issue. They could file tomorrow if they felt like the room was having sewage and mold and the other items that were mentioned. I think all we're talking about tonight is the actual physical reinstallation of the washer dryer, and beyond that, nothing is preventing a further claim with the city.
Okay.
That's my understanding.
And if I may add, Chair, yes, that's correct. The examiner order was to restore, but also the request for the inspection was specifically if the washer and dryer are operational, because I think the part of the tenant's testimony or at that point issue were that if the machines were installed but they were not operational, and that's what the tenant submitted the photographic image dated July 10th, which shows that these are disconnected, the machines. So which we could, one could assume that the machines were not operational, at least as of July 10th. But when the inspector went there on July 19th, they were connected. And that's what the inspection report confirms, that he pushed the buttons, they seemed responded. So that's, it's not just, I guess I wanted to say it's not just the appliances that were installed or purchased, installed, but also if they're operational. Yeah.
That's a good clarification.
Thank you.
What are your thoughts now?
Is there, it doesn't sound like we're disputing that the machines were installed and operational necessarily, although it sounds like from testimony that there's some dispute as to their operational ability and their access. Although that, in my mind, that is a bit muddy because they're saying some people don't have keys, however, homeless people have access because they break in and the doors are broken. But I do hear the tenants suggesting that maybe the machines are no longer operational. Is there room for us to amend the resolution for this in part as a matter of that, or is that just out of scope?
Well, what's your thought on the amendment?
I'm thinking that we can remand it back to the inspectors to I guess, go back and check that the machines are in fact working and the tenants have access to the laundry room.
Well, my thought is a couple things. On access, that's a totally separate issue. So
Okay.
if anybody wants to file tomorrow and say, I can't even get into this room, I've never been able to get into this room, there's nothing preventing anyone from doing that. So that's pretty clean. Same thing on cleanliness of the room. Same thing on any unhoused people who are frequenting the room. I imagine that could potentially be a loss of service by virtue of that happening. So all those issues, and this is for the folks who are listening, the tenants who are listening, if those are still happening, nothing that we do tonight, as far as I'm aware, would prevent anyone who's a tenant from making a claim about those issues. But as it relates to whether the machines were operational and installed on July 19th, again, I go back to substantial evidence. It seems like they were. I guess maybe that is a question for staff. Like, they were working on July 19th, but like today they're not working. They're no longer working. Somebody could make another claim with the city saying, as of, January 24th or whatever the date is, they're no longer working again. So or is that going to be caught up in the 6-month rule because we're dealing with operation of the machine?
You were almost right. It is almost January 24th. It will be in a few hours. But it's a little bit of a gray area because it would depend how they phrase their application. So every application when it comes in is looked at by staff to see if they filed in the past, looks at the history and whatnot. So I would think staff would flag this one and say, hey, this issue has come before us, but either, I trust staff, but if they came to me and asked me, what I would say is that you are correct. They could file again because the issue goes back to the compliance determination date of May, 2024. And so their argument would be starting on July, then it was broken again. So that would be terrible luck, but stranger things have happened. So that's how a properly filed new application would pass muster with us. If they just said it's broken, then we would have to, dig a little deeper.
Does that help satisfy your concerns, any?
Yeah, I think I'm inclined to lean to affirm the decision.
Okay. I'm going to switch to this end of the aisle. Commissioner Corpes?
Just going to address that issue. I think the only thing I heard that was questionable in terms of the same issue is the gentleman who said that he didn't have a key, was never given a key to access. And I would say, although I think the time has already gone by from the date now that we've, but I would say that that person, he would have to file or make a written request to the landlord to say, I have 30 days to give me the key. If the landlord didn't do that, then I think we're way past the 6-month point. But my point, I guess, would be saying that if you wanted to waive the 6-month on the key issue access for the gentleman who would still have to request a 30-day, give the landlord 30 days to give him the key, pretty bad landlord if you don't comply in 30 days. But that's where I see your point in, was it fully restored? But you're right, the other issues, the cleanliness, all that other stuff are brand new issues they could file tomorrow, today, if they wanted. But it sounds like I think enough time has passed that the 6-month rule isn't applicable anyway, right? Commissioner Hopchin, do you agree? Oh, that the 6-month would already have gone by. Yeah, so it's really...
Then there is no need to waive that period.
Yeah.
Otherwise, we could have waived it.
In that very select, very defined situation.
For the specific situation.
So are you likely to affirm?
I'm okay with affirming.
Okay. Commissioner Goldman.
Yeah, given that these other issues, they could file separately and have that dealt with, I'm inclined to affirm just on this issue.
Okay. And Commissioner McCafferty?
I'm okay with affirming.
Okay. And I likewise think we can affirm. I would, again, just reiterate for the tenants who are listening, if there are ongoing issues, you still have remedies. So this wasn't for lack of hearing what you had to say tonight. It's just on the narrow issue before us about installation and operation on July 19th. And the rent restoration, if the motion passes, is not going to be until August 5th. So effectively, you would have gotten the entire month of July for the tenants. Okay, so with that, I'm going to make a motion to approve. Oh, sorry.
Before we go into the approving the motion, I don't know if it makes sense or if it's even in bounds that, because if the tenants do file not a new appeal but a new request for, do they, where the staff would review this decision and the previous documentation for this decision, does it make sense for us to annotate or amend the
So I'll let Mr. Kessinger speak to what staff does when an application comes in. I don't think it's necessary to amend anything because the original decision and the compliance determination decision already speak to those issues, of which are included in this and which are not. So I don't think it's necessary in that case, but I do think when a rent reduction request comes in, does staff look back at prior cases and the file?
Yeah, generally staff would look to see if there had been a case filed for the property in the past 6 months. So that would be part of the review of the submitted application.
And so if we were to, I don't know, amend the resolution to suggest that the access issues were sort of open-ended, or give a note to staff to say, like, consider this when you're reviewing a new application, is that possible?
Short answer, no.
Okay, thanks.
I also just wanted to clarify something really quick for the record, because I think it's been stated a couple of times. The effective date of the restoration of rent was actually July 1st, 2024. The procedure looks a little bit different when there's a hearing and tenant objections come through. Then it's 10 days after the last day that the tenant would be able to object. So in this case, we've spoken about August 5th, but the date of change listed on the original compliance determination order is July 1st, 2024.
Okay, well, you guys snuck that one at the end there, so that's a little disruptive. What we heard tonight is some decent evidence that the machine weren't installed, let alone operational, as of July 10th. But now you're saying that the landlord's going to be able to restore rent for all of July, even though there's credible evidence that says as of July 10th, the machine wasn't even working.
That's correct.
Okay, and council agrees with that analysis?
Yes, because again, what you were trying to look at is what was in place when they filed the compliance determination request. So you've got to get away from that being the determinative date. It's the May date. And all that you're getting out of a compliance determination inspection is trying to support what was already in place according to the landlord in May. So if they filed their compliance determination request on May 5th and we had an inspector go there on May 10th, it would, you know, I don't know how to explain it differently, but is there substantial evidence of the record that on May 5th, these things were in place? The determination isn't the inspector's report. It's the totality of the evidence, but that's just one piece of the puzzle.
But just to tease that out, so a landlord, in theory, then could file a request for a restoration and not have actually restored the items, and then by the time the inspection occurs, they do get restored, and just by operation of the way the process works, the landlord gets the benefit of the filing date, even though as of the filing date, the service hadn't been restored.
Yes, but that's operating on the assumption that there's going to be a city inspection or something like that, or even a hearing, because a shady landlord, I said shady, not anything else, just to be clear, a shady landlord can do anything like you're suggesting, but a compliance determination, one, doesn't always have a hearing, and two, doesn't always have a city inspector go out there. So oftentimes it's done, court words is on the papers. So if they want to take that gamble that they want to get that extra month or two of restoration and be shady like that because they're waiting on an inspector, that could happen. But often they're just going off of, the hearing examiner is just going off of what's submitted by the parties electronically or by paper.
So what's that July 1st, 2024 date is for? Ms. Mencher, can you repeat that?
Yes, so that's the effective date of the change in the rent. So that's when the rent is restored, is July 1st, 2024.
And because, based on what argument?
So in the regulations, if a hearing is scheduled, the effective date of the change is 10 days following the first rental due date after 10 days following the deadline for tenants to submit an objection to a complaint.
If the landlord submits the compliance determination on May 31st, then the tenant is going to have, oh, I see, that would have been June. At some point, the tenants would have had an opportunity to submit their evidence, and then the first rent period after June would be July 1st. Is that how that works?
Correct.
Correct. Mm-hmm. And is this information is never included in the procedural background for our cases?
This is in our regulations, but no, it's typically not. And the reason there's a divergence in kind of what we've said is that it goes back to what I said. If they're just doing it on the papers and they don't have a hearing and they don't have an inspector, then it is what I said earlier, the next rental date following the decision. But if there is a hearing, then the tenants get time to object, and then once their time to object has ended, the restoration is the next rental date 10 days after their objection period.
Was there not an objection in that window?
It's not whether they file the objection, it's 10 days after their objection period has elapsed. So they have 10 days to file it, which would have been sometime in mid or early June. So it's the next rental date, which would have been July 1st.
Question. So I know that we're supposed to be looking at substantial evidence, but to me, if the hearing examiner believed he or she had substantial evidence, they wouldn't have sent out a inspector. That's just kind of my logic in this. And so I look at what's the totality of it, and the substantial evidence to me is that for sure on July 19th, things were resolved. And July 10th, they may not have been. I think it's equal. I think it's like substantial evidence that there is and substantial evidence there isn't. And in this case, the hearing examiner has reinstalled the amount, but according to our laws, our regulations, out of his or her control, right? That I think our law is messed up. I think we need to re-examine that for the future, because that doesn't seem fair.
It sounds like the reinstatement date would be July 1st, and we're saying that, like, ideally they should get August 1st as a reinstatement date. Is sort of the murmur in the back of, I think, all of our heads.
Right. Even though we don't have the power to change
Right.
the reg. Yeah. But this might be an opportunity to note, like I've been keeping a list at these hearings of things that I haven't particularly thought was fair or right, but realizing that's the rule. But to Commissioner Kirby's point, maybe this is an opportunity to have this looked at down the road if we made a recommendation for other changes.
And that's in the regulation, right? Not the RSO. Yeah.
Correct.
In front of us tonight, could we remand and make the hearing examiner determine between the evidence? Because he, or it wouldn't change the outcome though, would it? I mean, if either.
I think it would be.
He'd have the same question that's in front of us.
Correct.
Gotcha. Thanks.
Commissioner Goldman?
So it seems like we can see that on May 31st, or it was physically there, but because there wasn't an inspection, then I'm wondering, can we tell if it was operational? So that's kind of my question, is like, you can see the picture, you can see the receipt, but you can't reasonably tell if it's operational because we don't have any evidence to show that.
We do have the evidence from the tenants that the machines were not installed until after June 10th. I may have gotten that date wrong.
July
10th.
July 10th.
If I may, you only have evidence that it was outside of the room on that date. And so what staff has said in the staff report is, I believe from the June 10th photo, I don't want to misspeak, but it looked like the wash basin was out of the room on that date. And so staff believe there could have been work being done in there, that it was installed in May, taken out for some work, and then reinstalled by the 19th. But I just want to point out, a photo only shows on that date. So, again, the question is there substantial evidence of the record on, and I understand the kind of quandaries that you're finding yourself in. You do have to suspend a little bit of thinking of that gap in time, and that's just a function of when you file on May 5th, then the hearing examiner has to have some time to look at the record, determine if there's enough in there. That it's a process. So in an ideal world, we could pause time and then the inspector could go out on July 19th and nothing could change, but that's not the case. So you have to, the reasonable assumption that generally is made is that whatever you see on the 19th or the date of the inspection was always there. Obviously, there are a lot of variables involved there.
Is there? I mean, you're the lawyer, but like the reasonable person test accounts for the material fact that on the 10th the machines were not in place.
On that date, yes, but the question is not a reasonable person test. It's if you find that there's substantial evidence of the record, even if you would have ruled differently, you have to still uphold the hearing examiner's decision. So if it's 50-50, whether you would have gone left or right, you have to go with what the hearing examiner says. If it's a different number, then you can vote as you may.
So basically, we are really discussing whether during that 9-day period between July or no, 19-day period, if the service was available or not. And we just need to decide if it's substantial, as you said, we have substantial record that the service was substantially restored. I think the question before us is that it doesn't have to be exact. It has to be a substantial restoration of the service. I think that's the language in the ordinance to determine the rent should be restored. So now if you find that the appliances were purchased, received, and installed, and were operational at least on July 19th, would that constitute substantial restoration of the service based on what we just heard? Although initially we had the different dates, but I think after everything I heard, I would say I have no choice but to say yes, there is substantial restoration of the service. To be honest, that I can't really rule otherwise. By knowing also that the tenant may come back, may refile if, let's say, the services are not working tomorrow. So nothing prevents the tenant filing a new complaint. So I would still affirm the decision based even what we heard now, and I think there is substantial restoration of the service. Thank you.
Okay, I'm going to then make a motion to affirm resolution number RSC number 25-663, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's compliance determination as to application number D4689CD1. Is there a second?
Second.
All right, Commissioner McCafferty, second. Roll call, please.
Commissioner Goldman?
Aye.
Commissioner Kirby?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Paris?
Nay.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye. All right, the motion passes 5-1. And for those still at home, if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. Okay,
Mr.
great.
Chair, I just have a question. I missed, did somebody vote no on it? Oh, okay.
Commissioner
sorry.
Paris
All
did.
right. I heard
Yeah.
5-1 at the end. I was like, what? Okay. Thanks.
Are you okay?
Can I just say, because since during the testimony there was mention of harassment, and so can we just have staff just repeat the resources that are available for tenants dealing with that?
Yes, absolutely. Any tenant who feels that they're experiencing harassment should feel free to reach out to us at rsd@weho.org or by calling 323-848-6450. Tenant harassment in violation of the ordinance, is taken seriously by the city. There's a tenant harassment complaint form that can be submitted to the city for our review. So please feel free to contact us for more information.
Great. Okay, moving on, items from staff. Do we have any staff comments?
No items from staff at this time. Thank you.
Okay, great. Moving on to public comment.
No public comments at this time.
Okay, great. So items from commissioners. I know Commissioner Paris might have an item.
Yeah, I know that we spent a significant amount of time at the end of last year working on our look forward and trying to load balance a lot of the stuff, and things from beyond our control have sort of put a wrinkle in some of that. So I did want to thank staff for reworking that look forward and providing us with a massive volume of material, and I'm sure that all of the adjustments and moving those things around and the volume of material that you guys are working with are carefully put together for us. So I want to thank everyone involved in doing that. I also wanted to remember one of West Hollywood's residents who passed away last week, Francisco Pepe San Martin, who died last Thursday, and send our condolences to his family and loved ones in the city.
Commissioner Topchian?
Thank you, Chair. I just wanted to thank staff for really detailed and good report and, with these complex cases tonight, appeals, I should say. And of course, I want to thank you, Vice Chair, for doing such a great job chairing the meeting in absence of our Chair, Adam Bass. So I hope everything is fine and he'll be back. But thank you for doing a great job.
You're welcome. Commissioner McCafferty? No items. Commissioner Kerpes?
I'll just say ditto to what Commissioner Topchian said, and thank you to staff for, as he said, breaking these complex cases down into bite-sized pieces that we can manage.
Great. Commissioner Goldman?
I'll just echo thank you to staff again.
Yeah, likewise, it was a good night. We really gave each appeal its due. So, and thank you for reminding us at the beginning to pace ourselves so that we did that. And it was a pleasure working with you guys as always. And Adam, if you're listening, the gavel's ready for you when you come back. And with that, I am going to adjourn tonight's meeting. We are adjourned to the next regularly scheduled meeting to be held on February 13th, 2025 in West Hollywood Park, Council Chambers. Tonight's meeting is adjourned. Thank you.